A Miami, Florida ER doctor lost joint custody to her daughter because of the risks of exposure to the myshoronovirus. This is the literal manifestation of the expression, the road to hell is paved in good intentions. Viva Frei, Montreal litigator turned YouTuber, and if you can see through the window behind me, you might actually notice that it is snowing in late April in Montreal. Snowing, and it's actually cold. It's cold in this car. It's another car vlog because we are heading into week 8 of the myshoronovirus lockdown. And incidentally, I know people are messaging me to the effect that I no longer have to use the term myshoronovirus because YouTube is now allowing use of certain terminology without systematically demonetizing all videos on the subject. But I'm sticking with my term because I created it, I love it, I'm going to call it George.
I will name him George, and I will hug him and pet him and squeeze him.
Now, this story spread across social media like a wildfire, and it actually had something of a happy ending depending on your perspective, which itself did not make the rounds on social media quite as much. A Miami, Florida ER doctor who was also going through divorce lost joint custody to her 4-year-old daughter on the basis of the alleged risks that she presented to the daughter as a result of her work in ER treating myshoronovirus patients. The story made its way around the world and it caused outrage everywhere, and in my humble opinion, rightly so, in that it set an absolutely dangerous precedent as to the power of the courts to infringe on parental rights under the guise of the protection of the child. Now, I studied family law, but I never practiced family law because I didn't have the stomach for that field of practice. It is extremely emotionally draining. When it comes to establishing custody of the child, the court takes into consideration all the interests, but primarily the interest of the child. The interest of the child includes a number of factors, including most notably the safety of the child. So when I refer to the dangerous precedent that this court ruling set, it's not as relates to considering the safety of the child and determining who gets custody of that child. The absolutely dangerous precedent that this court ruling sets relates to what the court can deem to be a sufficient threat to the child to justify depriving one parent of custody of that child. Now, I wasn't able to get a copy of the court rulings in this file, so I'm relying on what I found in the news, but let's just quickly go through an article on the subject. An emergency room doctor in Miami temporarily lost custody of her 4-year-old daughter amid heightened fears over myshoronovirus. Before the pandemic, Dr. Teresa Green split custody with her ex-husband, Eric Green, for nearly 2 years. He requested full custody of their daughter last week via an emergency order in light of the myshoronovirus outbreak, which was granted by Bernard Shapiro of the 11th Judicial District of Florida, in order to protect the best interest of the minor child, including but not limited to the minor child's safety and welfare. This court temporarily suspends the former wife's time-sharing until further court order. Shapiro wrote in the order, according to WTVJ, TV in Miami, and CNN. The suspension is solely related to the outbreak. In this case, it was the mother. It could have just as easily been the father, but a parent being deprived of custody for the protection of the child, but only for the duration of the outbreak, however long that lasts. Eric Green's attorney, Paul Leonoff, said in a statement to USA Today that the court ruling has an addendum to provide, quote, future makeup time-sharing for Teresa, as well as, quote, daily video calls. We recognize and genuinely appreciate the sacrifices that she and all healthcare workers are all currently making to save lives and prevent further illness in Florida and around the world, Leonoff said. The Greens' temporary time-sharing dispute was presented before the court based upon the specific facts of this individual family. First things first, what a concession the court order provides for a future make-up time-sharing. When might that happen? 6 months? A year? 2 years? High school? University? Who knows? But we'll make up for the time that you were deprived of custody and video calls. What a concession to actual parental rights. Why don't you just hook me up to the Matrix ball right now so that I can have my rights virtually? But this was a statement that really led me to believe that there's a lot more going on in the backdrop, as there usually is, especially in family law cases. The Greens' temporary time-sharing dispute was presented before the court based upon the specific facts of this individual family. First of all, it's kind of a truism that the facts presented before a court are specific to that specific case. That's sort of what law is. It would actually be very bizarre if the facts presented to the court related to another family. But I have a sneaking suspicion, although I fully recognize I may be projecting my neuroses, but I have a sneaking suspicion that the request made by the father actually had to do more with his own safety than the safety of the child. Among the factors considered by the court, according to the court, were the child's safety and welfare. And the recycling people behind us have no idea that they have been permanently captured in one of my vlogs. Now, I don't know what evidence, expert testimony, or statistics were submitted to the judge to justify in his mind the rendering of this court order in the interest of the safety and welfare of the child, but we do have to look at the numbers, kind of. The Washington Post published an article with the headline, "The numbers are low until it's your child. The coronavirus can be deadly for children too," in which it wrote as follows. As of April 6, when the CDC published its last comprehensive report on the myshoronovirus and children, 2% of the confirmed cases had occurred in people under age 18. That mirrored data from China and Italy, which reported that children accounted for about 2% of infections. conditions. Children who test positive appear to experience severe symptoms at a far lower rate than adults. Relatively few children with the myshronosaurus are hospitalized, and fewer children than adults experience fever, cough, or shortness of breath, the CDC wrote in that April 6th study, which also made it clear that, quote, severe outcomes have been reported in children. As of Tuesday, the CDC's data included 2 deaths of children between the ages of 1 and 4, 1 death of a child between 5 and 14 years old, and 17 deaths of people between 15 and 24. I don't know what evidence was presented to the judge, but it seems that as of April 6th, according to the CDC itself, there were 3 deaths in people under the age of 14 years old. While the myshronosaurus does in fact pose a risk to children, the statistics are what they are, and could they warrant depriving a mother of custody of her child? I have a sneaking suspicion that the bigger issue here was not necessarily the risk to the child, but the risk that that child posed to the father. Every time that child had shared custody with her mother, there would be a risk that she could then bring the myshronosaurus back to the father. In theory, because of this cross-exposure, maybe the child can't visit the grandparents, maybe the father can't visit his own parents. It probably causes something of a massive inconvenience to the father in the way in which he conducts his life.
Alright, and I actually had something of a funny or hyperbolic example to give here, but given YouTube's new policy, as stated by Susan Wojcicki, I decided to err on the side of caution and not include any humor that could possibly be misconstrued as actual information. Incidentally, stick around to the end of the video if you want to hear the actual soundbite of Susan Wojcicki actually saying what I actually just said she said.
It is not to attack or undermine the intentions of the father. I have no doubt that he is looking out for the best interests of his kid. I just suspect that there are other factors going on in the backdrop that are not necessarily directly related to the actual risk that the myshronosaurus poses to a 4-year-old. While the story of this judge's order spread across social media like a wildfire, what did not spread quite as quickly across social media was the Court of Appeal suspending that judge's order. Appeals court temporarily allows ER doctor to keep child custody during pandemic. A Miami appeals court has suspended a judge's order that ruled an emergency room doctor lost custody of her daughter during the myshronosaurus pandemic, the Miami Herald reported. Miami's 3rd District Court of Appeals issued a stay for Judge Bernard Shapiro's order to allow physician Teresa Green's ex-husband, Eric Green, to have full custody of their 4-year-old daughter. With the order suspended, Teresa Green will continue to share split custody as the legal process continues. Her lawyer, Stephen Nullman, wrote in a statement obtained by The Hill that split custody will be, quote, temporarily restored effective immediately, and he and his client were thrilled with the result. While we are beyond grateful for today's ruling, we know that this matter is far from over. The original ruling giving Eric Green full custody during the pandemic caused an uproar in the medical community, including the American College of Emergency Physicians. The group's president, William Jacques, said in a statement to The Hill that the organization stands in solidarity with Teresa Green. Now, it's a practice that good lawyers learn sooner or later, and it's a good practice for everyone to adopt in discussion. In as much as possible, one should avoid attempting to impugn the intentions of the person with whom they are having a discussion. One should avoid trying to presume someone's intentions, and one should avoid trying to demonize those intentions. So when it comes to the father's motivations for the motion for sole custody, and when it comes to the court's rulings, I'm going to operate on the basis that they were both, in fact, operating in the best interest and safety of the child. That being said, had this not been overturned in appeals, how dangerous of a precedent would this be? Setting aside the specifics of this illness and the risks it poses to children as detailed by the CDC itself, the court can now unilaterally deprive a parent of custody of their own child because of risks to an illness? I did a vlog complaining about the nanny state of Montreal canceling Halloween because of the anticipated weather. This is next level and it's dangerous.
Yesterday, I did a poll in the community tab on my YouTube channel asking what the subject of my next vlog should be. Should I do a breakdown of the Yaniv situation and the recent judgment rendered by the British Columbia Human Rights Tribunal, or should I do a vlog on self-representation and what I think of it, whether or not I think it's a good idea? Well, the votes were surprisingly split, but surprise, surprise, I'm doing neither of those subjects. Why? Because the city of Montreal just announced that they are canceling Halloween.
#triggered.
It's dangerous because of the actual facts of the specific situation as per the statistics detailed by the CDC, but it's dangerous as a general precedent. It is a dangerous and unjust penalty to those who risk their lives doing the things that society needs the most. And it is a dangerous usurpation, if that is a word, of parental rights at large. I've said it before and I'll say it again, in law there is the legal side and there is the human side. And when it comes to family law, there is a lot more of the human side. And I strongly suspect there's a lot more to the human side in this case than we know of. All that to say, the Court of Appeal has stepped in not just to overturn that precedent, but to set its own precedent as to what the limits of the court are. One thing is for certain, and we're already seeing a lot of it, is that coming out of this myshronosaurus era, we are going to see the courts setting a lot of precedent as to what can and cannot be done even in a time of crisis, and hopefully they set the right precedents. With that said, if you like my content, please consider liking, subscribing, dropping a comment in the comment section below, share my channel with someone who you think might appreciate it as well. If you want to support the channel, the support links are in the pinned comment below, and above all else, be kind, be thoughtful, be understanding, give everybody the benefit of the doubt to the greatest extent possible, and now you know your vlog. Peace out. Booyah.
Yeah, and so we talk about that as raising authoritative information. But then we also talk about removing information that is problematic. Of course, anything that is medically unsubstantiated, so people saying like, take vitamin C, take turmeric, like those all will cure you. Those are the examples of things that would be a violation of our policy. Anything that would go against World Health Organization recommendations would be a violation of our policy. And so remove is another really important part of our policy.